Hello everyone, welcome to the IMPRINT Explained. Today we're looking at the Indian Polity and Constitution series, and that is in news. And we're looking at the First Amendment and the ninth schedule of the Indian Constitution. Right. So the ninth schedule has been in news because of the demand for putting reservation in the ninth schedule, right? Because of the recent Supreme Court judgment. We'll talk about that a little later in this video. If we don't talk about the First Amendment, which actually led to the ninth schedule, it would not be right. So we'll start with the First Amendment and then we'll go to the ninth schedule, right? So there are a couple of books, I think, in which the story of the First Amendment of the Constitution is there, and this is by Tripur Daman Singh, and it says 16 stormy days. And there was a huge debate about the First Amendment. What was that? We're going to talk about that, right, in this lecture. Okay, so in the First Amendment, that is 1951 Act, the Constitution First Amendment Act 1951, it made several changes to the fundamental rights provision of the Indian Constitution. So that was the biggest thing that happened. Also, it provided against abuse of right to equality, right to property, against and wanted validation of the zamindari abolition laws. It clarified that the right to equality does not bar the enactment of laws, that is 15,3, right, for the weaker sections of society, and it talks about Article 46 in this. The formal title, obviously, is the Constitution First Amendment Act. It was moved by Jawaharlal Nehru on 10th of May 1951, enacted on 18th of June 1951. Okay, so within the same year, right? And this amendment set the precedent of amending the Constitution to overcome judicial judgments impeding the fulfillment of government's perceived responsibilities to policies and programs. So the latest, you remember that there was a judgment against the Scheduled Caste and Scheduled Tribe Atrocities Act by the Supreme Court, in which it made the offense bailable, and the Modi government went and amended. First, it issued ordinance and then again put an article there, right? Again, passed the Scheduled Caste and Scheduled Tribe Amendment Act, right? Atrocities Act. So basically, the idea was that now this became a precedent, right? It was like a fight against the legislature and the judiciary in some ways. So what happened? Why? So, okay, everybody understands validation of zamindari law. There was a huge demand. There was anti-zamindari movement. There's a peasant movement from 1937. So, yes, zamindari abolition laws, validation they have to be protected from right to property, Article 14, 21, 19, and so on. But what happened with Article 19? So in 1950, a leftist weekly journal in English, Crossroads, right, published by Ramesh Thapar, was banned by the Madras state for publishing views critical on Nehruvian policy. All right, and he petitioned the Supreme Court, and it led to the landmark judgment of Ramesh Thapar versus State of Madras on 26th May 1950. This eventually led to the Nehru's administration limiting provision of Article 19(1)(a) of the Constitution against abuse of freedom of speech and expression. Okay, so in some ways, right, in other countries, so in USA, the freedom of speech is absolute. India, it is not. So there's a reasonable restriction. So some people say it's the fraud on the Constitution. The First Amendment was the first fraud on the Constitution, and it's a criticism of Nehru. Some courts obviously had held also what other reasons why this was done. Some courts had held the right to freedom of speech or expression granted by Article 19(1)(a) of the Constitution was so comprehensive that it rendered a person culpable, right? Even if he advocates murder or other crimes of violence. So you can say anything. So there has to be a reasonable restriction. The idea is obviously, where is the freedom of speech or expression? What level to it? Obviously, remember, it's an opinion. Obviously, if it leads to incitement of violence, obviously it's wrong. Jawaharlal Nehru encouraged the Parliament of India to pass the amendment in response to the state of Madras versus Champakam Dorai Ranjan. So what happened in this case was that a Brahmin woman in Madras challenged the state's communal general order. तो इसमें क्या था? कोटा होता है गवर्नमेंट सपोर्टेड मेडिकल एंड इंजीनियरिंग कॉलेजेस में. सो उसको अगेंस्ट इन्होंने चंपकम दोराजा ने पहला केस किया कि भाई मेरे अगेंस्ट है, राइट, इट इज अगेंस्ट आर्टिकल 14, इट इज आर्टिकल 21. सो obviously Champakam Rajan was seen to be correct by the courts. So against that, Nehru said we have to protect 15,3 as well. Okay. Also, there are certain amendments in respect to articles dealing with convening and proroguing of sessions of Parliament, which also when there were minor amendments in 341, 342, 372, and 376. But maybe that is not that relevant. I don't expect a question on that. Okay. Now the question is why ninth schedule is in use. So LGP leader Chirag Paswan, he said that reservation should be put under the ninth schedule of the Constitution. His comments came after Supreme Court ruled that reservation in matter of promotions in public posts was not a fundamental right, and that the state cannot be compelled to offer the quota if it chooses not to. And this was the case, obviously, the Uttarakhand case, right? And in which the BJP government has been criticized heavily. Now, some people are saying it is the RSS anti-reservation wing which is coming into the forefront for that. But Chirag Paswan says it's high time that the reservation is put on the ninth schedule. Now, what is the ninth schedule? The ninth schedule contains a list of central and state laws. So it will be like something like the ninth schedule. So it is under Article 31B, and you'll have a list of various articles of Bihar Land Reforms Act, Bombay, Tennessee and Agriculture Act, and so on. There are 284 such laws. Okay, and the schedule became a part, as we said, on the First Amendment, 1951, right? It created a new Article 31B along with 31A to protect laws related to agrarian reforms and abolishing the zamindari system, right? While 31A extends protection to classes of laws, right? 31B shields specific laws and enactments. Okay, so that is the idea behind. So one article I've created a class. These laws classes can be protected under this, and 31B specifically says that this law is under this, and you cannot talk. Judiciary cannot actually have a say in this. Now, what happened? Why did this happen? What did Nehru say? तो नेहरू कहते हैं कि agrarian trouble हो, land tenure में कुछ पता नहीं क्या होगा. So there's no point in having long arguments and repeated appeals, because हो क्या रहा था, land reforms को curtail करने के लिए तारीख पे तारीख चल रही थी, केस पे केस हो रहा था, right? So obviously it was expected. What happened was इसी से land reforms खराब हुए थे because of this court. Okay, so इसी वजह से इंडिया में कभी भी कोई big revolution नहीं आया, right? Status quo maintain हुआ है, feudal society रही है हमारी, right? So from the security point of view, from food production point of view, from the individual point of view, right? तो basically ये जमींदारी सिस्टम को खत्म करना है, उसके लिए and क्यों खत्म करना है? Because जमींदारी systems की वजह से agriculture की productivity बहुत कम है. That was the connotation behind this. Now 31B क्या कहता है? 31B कहता है without prejudice to the generality of provisions contained in 31A, none of the acts and regulations specified in 9th schedule or nor any of the provisions thereof shall be deemed to be void or even have to be void on the grounds such the article regulation is inconsistent with some fundamental right. That's the basic idea, right? कोई judgment, tribunal order कुछ भी हो, right? ये basically आप छू नहीं सकते हैं इन चीजों को, right? So that is the basic idea, and this is the exact article quoted here. Now, first amendment के बाद 13 laws ऐड हुए थे, right? Subsequent amendments हुई, तो basically इसका misuse बहुत किया गया है. Now problem is 9th schedule जिस चीज का इतना misuse हुआ है कि obviously judiciary में in some time बोला कि भाई ये गलत है, right? It would be open to scrutiny if they violated the fundamental rights or basic structure of the constitution. So ये IR कोहेलो केस है, इस पे डायरेक्ट यूपीएससी में क्वेश्चन आ रखा है. So इसमें बोला सुप्रीम कोर्ट ने बोला कि लॉज प्लेस इन 9 शेड्यूल्स आर ओपन टू जुडिशियल स्क्रूटनी बेसिकली. तो सुप्रीम कोर्ट ने बोला कि डुअल टेस्ट हमने डाल देते हैं इसके लिए कि वेदर इट वायलेट्स फंडामेंटल राइट एंड इफ यस वेदर द वायलेट्स आल्सो डैमेजेस द बेसिक स्ट्रक्चर. अगर ऐसा है, दोनों अगर ये बोथ यस है तो बेसिकली आप इसको अनकॉन्स्टिट्यूशनल डिक्लेयर कर सकते हैं ऐसे कोई लॉ को, राइट? मोस्ट लॉज इस शेड्यूल में एग्रीकल्चरल लैंड इश्यूज के, सिर्फ एक है जो रिजर्वेशन का है, दैट इज तमिलनाडु का लॉ है, इसमें प्रोवाइड्स रिजर्वेशन दैट इज 69%. तो ये ऑब्वियसली ओवर द नागराज केस है, 50% से ज्यादा रिजर्वेशन है इसमें. सो दैट इज व्हाट इज देयर हियर, right? This is the exact 31A article, right? In case you want to go through this. So ये क्या exactly कह रहा है? The saving of laws providing for acquisition of estates. So क्या कहता है? The acquisition by the state of any estate of any rights therein or the extinguishment or modification of the rights, कि अगर कोई मैनेजमेंट ऑफ प्रॉपर्टी हम ले रहे हैं फॉर द टाइम इन स्टेट ले ले, जैसे अब अभी रिसेंटली कोरोना वायरस चल रहा है, सो कोरोना वायरस में इफ वी टेक ओवर द मैनेजमेंट ऑफ लेट्स से हॉस्पिटल्स, ऑल द प्राइवेट हॉस्पिटल्स इन इंडिया, राइट, सो फॉर लिमिटेड पीरियड इन पब्लिक इंटरेस्ट, तो अलाउड है, ठीक है ना। और अगर मैं बोलूं कि अमालगमेशन करनी है दो कॉर्पोरेशंस की, राइट, जैसे अगर मैं बोलूं कि येस बैंक और एसबीआई को कर दो, राइट, अमालगमेट कर दो पब्लिक इंटरेस्ट में, तो वो भी इसके अंदर आ जाएगा, राइट, एंड सो ऑन। देन एक्सटिंग्विशिंग वोटिंग राइट होल्डर्स, जैसे आप सपोज करो येस बैंक में मैं बोल रहा हूँ कि मुझे राइट था, मेरे पैसे डूब रहे हैं, आप मुझे पैसे वापस कर दो, एक्सटिंग्विशमेंट ऑफ राइट भी किया जा सकता है। नेशनलाइजेशन के लिए काफी यूज था ये, यूजफुलनेस थी इसकी। फिर कोई भी एग्रीमेंट लीज के लिए प्रीमेच्योर कैंसिलेशन जैसे 2G स्कैम में हुआ, तो भी इसके अंदर आप कह सकते हैं। दैट इज द बेसिक आइडिया हियर। Now this is just to have a look here, ऐसे 9 शेड्यूल में कौन से ऐसे लिस्ट है लंबी सी, 31B में बिहार लैंड रिफॉर्म्स एक्ट, राइट, बॉम्बे कोठी अबॉलिशन एक्ट, मद्रास स्टेट अबॉलिशन, कन्वर्जन टू रोटवारी एक्ट एंड सो ऑन। Okay, now I think we covered this topic briefly. Let's look at prelim question which you can solve. So question, right, which of the following statement is not correct considering the 9th schedule of the Indian Constitution? It was added by the first Constitution Amendment Act. This is correct. It was introduced by Jawaharlal Nehru to the Parliament. Yes, we have read about this in this lecture itself. The inclusion of any law under the 9th schedule requires amendment under the Article 368 by special majority. True. Right, and it brought under the purview of judicial review in the Kilhoto-Holan case. So this is not true. This is for anti-defection, right? I think in another lecture, this is the previous lecture to this, we talked about anti-defection, and this case is talking about anti-defection, right? So obviously this is incorrect. This is IR Kahelo. So answer is D. Right. Okay, thank you so much for listening. Do subscribe and like our channel. It was a very short video. Hope you like it. Join the Telegram group for the video of this lecture.